Welcome. My name is Rainey Reitman. I am the Activism Director of the Electronic Frontier Foundation, which is a nonprofit civil liberties law firm and technology center based in San Francisco. I work on issues related to privacy and government surveillance and freedom on the internet. And today we are going to be talking about those things, and I see we have some latecomers, and just for everybody to know, we are going to be live streaming this on the internet. So if you're uncomfortable with that, you can always leave, but I hope you stick around. We are also going to be broadcasting this on C-SPAN, and we are going to have recordings available, so if you miss anything, you can always watch it later. Everyone who came into the room should have a little piece of paper in their hand. If you have questions during the course of the panel, write it down on there at a couple different points during this panel. Some of our friends over at Free Press are going to be walking around the room. I'll make a little announcement, and they will be picking up any questions you may have. They will be bringing it to me. I will be reading them. Questions that I think will be particularly interesting to this audience, I will read out loud to our panelists and give them an opportunity to respond. And I am also open to collecting questions on Twitter, as is the more technical way of collecting questions from a panel. So if you want to tweet your question rather than write it down, you can use the hashtag NCRMPriv, as in short for privacy. NCMRPriv. All right. And I will be monitoring that stream. And maybe some people can tweet that out, and I will retweet it, and that will help expedite things. So without further ado, I am extremely pleased to have a very distinguished group of panelists who have actually, many of them have flown in from different parts of the country. It's a particularly interesting group today because we have technologists, we've got researchers, we've got an activist, and we have a lawyer. So we have what I think of as the perfect spectrum of digital rights defenders sitting in one room today, willing to talk to you very frankly about their thoughts on government surveillance, what the problems are, and what you and I should be trying to do about it, and whether or not there's even anything we can do about it. I'm hoping to sort of move back and forth free flow style between government surveillance issues and privacy issues as far as consumer and corporate collection of data. And so as this sort of moves along, feel free to, again, write your questions down. I'm going to go through and introduce people, and then we're just going to jump into it. I know a lot of panels like to have long introductory remarks by folks, and I promise you that this long introductory remark has been the only long introductory remark you guys will have to suffer through. So our first panelist is Sita Gangaran. Raise your hand a little. She is a senior research fellow at the New America Foundation's Open Technology Institute. Her research focuses on the nature of digital inclusion, including the potentially harmful aspects of internet adoption due to data mining, data profiling, and other forms of online surveillance and privacy-invasive practices. She is a longtime contributor and ally of the media justice movement. Peter Myszek is Policy Counsel for Access, where he manages telecom advocacy, advancing the dialogue toward a more rights-respecting telecommunications environment worldwide. A lawyer by training, Peter also tracks and campaigns new cybercrime laws in countries from Peru to Iraq. Jonathan Mayer is a graduate student in computer science and law at Stanford University, where he is a cybersecurity fellow at the Center for International Security and Cooperation and a junior affiliate scholar at the Center for Internet and Society. And Cade Crawford is the Director of Technology and Liberty for the Technology for Liberty program at the ACLU of Massachusetts, where she quarterbacks the work challenging the growing surveillance state and defending core First and Fourth Amendment and due process rights. So I wanted to kick off this discussion by describing one of the major surveillance battles that we've been facing over the last few years. And it's a story that's particularly close to my heart, which is the story of Mark Klein. Mark Klein was a 64-year-old retired AT&T technician who came out publicly, including coming to my organization, with schematics, plans, detailed blueprints from AT&T's Folsom Street facilities in San Francisco. And these plans showcased a secret room based in AT&T's facilities. It was locked on the inside. We've actually seen pictures of it. And inside this room was a fiber optic splitter that created a copy of the internet communications of Americans and sent it to the National Security Agency. Kate, I wanted you to kick off this panel by talking about what is the National Security Agency? What does this kind of surveillance mean for everyday users?
Sure, thanks, Rainey, and thanks everybody for waking up so early to come hear us talk about this scary subject. I hope it doesn't give you nightmares all the way later tonight. So yeah, I mean, the NSA is an organization that is extremely secretive. We actually don't even know how much money we spend on the NSA. There are about 30,000 employees. It's larger than the CIA. It's a really huge bureaucracy, actually. And, you know, over the past 12 years since 9/11, we've learned a substantial amount about what the NSA rather has been doing, only because of people who have left the NSA and blown the whistle on some of the abuses going on there. So I'm just going to give you like a very brief sort of chronology of what's happened since 9/11. So after 9/11, we now know the NSA took the gloves off, is how people have described it. And that's to say the NSA, for a long time, its mandate was to surveil overseas communications, right? To look for, you know, information in foreign countries. So, you know, the NSA could, in other words, listen to people in England having conversations with people in Pakistan or in Sweden without warrants. This has been the case for a long time. But the NSA's First Amendment, as whistleblower Thomas Drake has said, was for a long time that the agency never spied on Americans without warrants. That changed after 9/11. The gloves came off, and suddenly the NSA, as Rainey has said, was sucking up vast quantities of our internet and phone communications, you know, data mining them, looking for so-called terrorist patterns, and, you know, essentially operating a dragnet spying operation, which included the private communications of Americans, people in this country, and doing so without specific warrants. So we learned that actually too late, much too late, in 2005 as a result of a New York Times story that broke that news to the public. The New York Times, by the way, you know, it's important to say at a media conference, the New York Times sat on that story for a full year. They knew, you know, they had received information about what was going on before the 2004 election, and they did not tell the public until after the election. They did that on purpose. They said that they did it because the journalists needed more time to research the story at the request of the Bush administration. It's pretty clear to anybody with a brain that they did it to wait until after the election, right? So anyway, in 2005, this is what we learned. Later, there was a massive outcry in this country, you know, opposing this warrantless surveillance. So what does Congress do but enshrine it into law in 2008 with the FISA Amendments Act? So essentially the FISA Amendments Act legalized this warrantless spying program. Not only did it legalize the warrantless spying program, it also immunized companies like AT&T, who had, as Rainey described, provided the NSA with our communications without warrants from any lawsuits. So, you know, the U.S. public can't sue AT&T now, you know, because they violated our rights, because Congress protected them from those lawsuits. So the FISA Amendments Act, yeah, of 2008. So that was 2008, right? Just recently, in December, well, I should back up again and say, the day that the FISA Amendments Act passed and was signed into law, the ACLU filed a lawsuit opposing it. There have been recent developments just within the past few months that are extremely important as they pertain to the NSA's surveillance and the FISA Amendments Act. One of them is that in December of 2012, just days after Christmas, when everybody in this country was paying zero attention to what was going on in the news, Congress rushed through a reauthorization of the FISA Amendments Act with hardly any debate. It's really just shameful, actually, what Congress has done in this respect. So passed FISA Amendments Act through without any of the, very, very minimal privacy and transparency amendments that some sort of valiant senators had proposed. And so we now are stuck with the FISA Amendments Act through 2017. There will be no debate about this law. There is no opportunity to challenge it now because just this past February, the Supreme Court ruled in a 5-4 decision that the ACLU's lawsuit challenging FISA Amendments Act could not even be heard on the merits because our clients, a group of human rights lawyers, activists, journalists who essentially said to the government, look, we believe that because you're spying on American communications with foreigners without warrants, that our private communications that are very, very sensitive, having to do with people whose human rights have been abused by the U.S. government, lawyers who are handling cases at Gitmo, they said, we think you're spying on our communications. We think it's unconstitutional. We want to sue. The Supreme Court said 5-4. You don't even have an opportunity to sue because you can't prove that you've been spied on. So this is the sort of catch-22, Kafkaesque. It's actually sort of garish and nightmarish, what the kind of legal situation that we've found ourselves in. Congress and the courts have entirely abdicated responsibility. And so, that is a much larger problem, though. I think that some of the things that we're going to talk about on this panel will elucidate that. Congress has, if they've done anything in the surveillance and privacy space, it's been to make things worse. And, we have a whole separate set of issues, which I think Peter's going to talk about the Electronic Communications Privacy Act and the Stored Communications Act, which are so obsolete that they essentially don't protect our emails from warrantless government searches. So Congress hasn't acted to update privacy law to bring it into the 21st century, and on the other hand has actually set us way, way back by doing things like passing the FISA Amendments Act again for 5 years without any debate, without any transparency or any kind of amendments. The last thing I just want to say about that is that people like Bill Binney, who devised actually some of the data mining programs that the NSA still uses, who's a whistleblower, left the agency, has now said that he believes that the NSA is going beyond even what FISA allows, which is to say that he believes that the NSA is sucking up all of our communications, even domestic to domestic, and essentially maintains a file of every email ever sent, every phone call ever made, every text message. So what he has described as sort of a totalitarian society could be turned on with the flip of a switch, is what he says. That the systems are all in place. The NSA is building a data center in the middle of the desert in Utah, which is going to be able to hold, essentially all of the information, the digital information produced in the world for 100 years. So after I've just, really uplifted your spirits, I'm going to pass the mic back. Thanks.
Thank you, Cade. So I wanted to read something. I wanted to read the Fourth Amendment of the Constitution, which is supposed to protect people from unreasonable search and seizure. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Peter, you're a lawyer. How can the government be doing all those things that Cade described and engaged in this kind of mass surveillance without running afoul of the United States Constitution?
Thanks for the question. It's a good one. I just want to take a step back and look at the Fourth Amendment, which I think is pretty good. It sets out the substance, unreasonable searches and seizures. It talks a little bit about what it covers, your papers, effects, and it sets out some procedural aspects as well. So, all things told, this was a pretty good principle to put in place, and I'll talk a little bit about the limitations, but I just want to acknowledge that it set up a pretty good system whereby this one principle could be reinterpreted, for the years to come. A couple of the limitations, though, I want to highlight are, one, structurally, the amendments to the Bill of Rights weren't designed to protect us against corporations, perhaps because they didn't exist. And the structural limitation I could talk about personally for losing data to a corporation. So I just want to say in the summer of 2001, I had some computer problems. It was crashing, so I sent my machine in to a computer manufacturer in Texas, and then I went and studied abroad. While I was over there, 9/11 occurred, and a couple months later, my mom got a message back while I was abroad that suspicious literature had been found on my machine. The computer came back sans hard drive. So, either a pretty crafty postman took my hard drive, or, I'm very privileged. I was able to buy a new machine, but the Fourth Amendment was not designed to protect me from that very unreasonable search and seizure of my hard drive, because it applies to the government. The second limitation is, the language, unreasonable. What does that mean? It's left to judges to decide. What does it cover? It talks about your house, your papers, effects. It doesn't talk about things in the cloud, as we all know. So what I wanted to lead to was one of the interpretations of unreasonable searches, and that is what's known as the third-party consent doctrine. In the 60s, courts were starting to get hip to wiretapping and starting to draw the bounds of, the Fourth Amendment talks about our houses, but what happens when we leave our houses? What happens when data leaves the house? And talk about the bounds of, public and private. So one of the decisions, the Miller case, looked at bank records, information you share with an institution like a bank, and saw that you consented to share that information with them, and decided that your consent would carry over for whatever ways that institution wanted to share your information, be it with the government or third parties. So that became known as the third-party consent doctrine. It's got some corollaries with wiretapping, the Hoffa case, and it has a lot of implications these days because we share so much. We're transmitting information right now that we're sharing with our telecommunications providers, perhaps the equipment makers. We don't necessarily know the extent, and the government is able to use this doctrine to get at that data because of the way the Fourth Amendment has been interpreted. More specifically, about 10 years later, the Stored Communications Act became part of ECPA, the Electronic Communications Privacy Act. This was dealing largely with email, the Stored Communications Act, which kind of was really at the forefront, and its author saw that email was being downloaded from servers onto people's machines, and tried to come up with a threshold for when that email, that stored data, the content information, that's possibly sensitive business information of ours, when that was no longer so sensitive, and came up with a 180-day limit. Because if you didn't download something and you left it on some server, you obviously didn't want it, right? So
the goal of ECPA was actually to protect privacy.
It's called the Privacy Act. Yeah.
Yes. So it was put into place in 1986 to protect privacy.
Yeah, and so things have changed, but Congress hasn't caught up, as Kate said, and that law is still in place. And so the government can, without a warrant, with simply a subpoena, which just can be issued by an attorney, doesn't go before a judge, can access that content information. And there's a number of other laws, patchworks, that have been stretched and wrangled and really destroyed in order to kind of adapt to this internet age, the mass amount of electronic communication. And these laws were not designed for today's day.
Randy, can I just say, it's true that Congress has thus far failed to update ECPA, but that might change very soon, actually. So if you're not already, you all should join the email lists of EFF and Access and the ACLU, and you will receive email action alerts asking you to please contact your legislators about ECPA reform, because it seems like we might actually get a warrant for all email within the next couple of years, or maybe even sooner than that. This has been a long running battle, and I think we might actually win. So please get involved, call your legislators, tell them that you want your email protected with a warrant standard, because I think it might actually happen. So that's some good news.
Well, I second that. So I wanted to talk in particular about the role that corporations are playing in government surveillance, because I think we've already started to see a hint of that. We talked about how AT&T had put together a secret room and fiber optic splitters. And if there's nothing else that you walk away with this panel, I want you to know that there's a very important role that corporations play in allowing this type of surveillance to take place. And in December of 2011, the whistleblower website WikiLeaks began releasing very interesting documents. They were releasing documents about the surveillance industry. And to date, they've released 287 files on their website about this, documents they call the spy files. These documents detail the activities of surveillance companies, the companies that build the backbone of surveillance used by governments in Egypt and in Libya and in China and in other places. And I wanted to read a little portion of WikiLeaks' media release. They said, "The industry is, in practice, unregulated. Intelligence agencies, military forces, and police authorities are able to silently and en masse and secretly intercept calls and take over computers without the help or knowledge of the telecommunications providers. Users' physical locations can be tracked if they are carrying a mobile phone, even if it is only on standby." Jonathan, you're a technologist. Can you talk to us about how this is actually happening? How are these companies able to take over computers, to physically track locations of phones? How are these contractors, how does this work?
Right. So, in short, it's not that hard. Technical surveillance is something that the internet was, to a rough approximation, not built to withstand. The internet was built to be resilient against parts of it stopping functioning. It's very good at connecting networks of different types, but there aren't really privacy or security guarantees built in. And so if some entity, whether it's an internet service provider or a government that sits between you and whoever you're talking to, decides they would like to intercept your traffic, modify your traffic, to a first approximation, the internet's not going to do much to help you out. The way computer scientists think about these problems tends to be in layers. So there is a layer that represents the physical connection between your device and a network. Then there's a layer that represents the internet protocol. It's the protocol that all devices on the internet speak. Above that, there's some applications that you may be running that are talking to each other. At each of those layers, there's a possibility of compromise, of, in fact, building in various sorts of backdoors. And there's also the possibility of building in various sorts of privacy and security guarantees. While it's easy to build intrusive technologies, it also turns out it's not too hard to build technologies that provide protection for users in ways that perhaps the legislatures in this country and other countries and the courts have been somewhat reluctant to do. And so I want to briefly touch on some of the protections that may exist at any of those layers to help you think through this in very roughly the way a computer scientist would. The three properties that tend to get thought of a lot are confidentiality, integrity, and authenticity. So the idea of confidentiality is someone else can't read your communications. Integrity being someone hasn't tampered with your communications, and authenticity being that you're talking to who you think you're talking to. And actually, there have been good ways of guaranteeing these properties for a number of years. It's very well studied problems in computer science. But it turns out, well, in theory, these properties are fairly easy to, are fairly well conceptualized. In practice, they're actually kind of hard to implement. So this brings me to the second point I wanted to be sure to address about consumer protection or user protection as against interception, modification by companies or government. So it's really easy to get this stuff wrong. And so the best way to ensure that a technology you're using to protect yourself against some sort of surveillance is having it vetted. there are plenty of experts who spend all their time making sure these technologies are implemented correctly. And there are some technologies that have been thoroughly vetted. There are many that have not, though. So, for example, you may have seen in the news over the past few days some discussion of whether the government can intercept iMessage communications. This is Apple's chat protocol. And it's not entirely clear, in part because the iMessage protocol isn't documented, it hasn't been vetted, and so that's why the conventional wisdom among computer security experts tends to be you should hold off on making bold claims about what is or isn't interception proof until we have a much better idea of what's going on. So let me give a concrete example of that, some research that was done in my lab at Stanford looking at implementations of secure web communications by mobile apps. So in theory, these properties of confidentiality, integrity, and authenticity are fairly well solved in the web. If you've used a browser, you've seen some sites you go to are prefixed with HTTPS instead of HTTP. That means your browser is making some attempts to guarantee those three properties. It turned out that some mobile apps were using HTTPS to communicate, but in the process had not actually checked the identity of who they were communicating with. So it was a bug in these programs. So as long as a server responded with some valid HTTPS response, not necessarily identifying itself as who the mobile app was talking to, then the app would go ahead and chat away, share user credentials, share user information. So this is a great example of secure in practice, or secure in theory, insecure in practice. The last point I want to touch on in the design of these technologies that could protect users in ways that the courts or legislators have not, is in their design. The first component of that being whether it's a security property as between users or devices, so providing these guarantees between the users and devices using the system. So is a communication encrypted, authenticated, from my phone to whoever I'm talking to's phone, or is it encrypted and authenticated to whoever the cloud provider is for this messaging service? But then once it's in the cloud, the message might no longer be encrypted. So if government were listening in to what was going on, the communication between my phone and the cloud, they couldn't get anything. But the government could, for example, order disclosure by the cloud provider. So let me give a concrete example of a time when this has come into play. The David Petraeus Gmail debacle involved a communication service, Gmail, that is secure from a user to the cloud. So Gmail uses HTTPS. The NSA presumably, not that they would have, but suppose they had wanted to, presumably could not have intercepted the emails going from David Petraeus' computer to Google. But of course, law enforcement could show up at Google with a warrant, valid warrant, and Google could produce those emails. This is actually a very ambiguity that's playing out now in the iMessage news coverage. There's an open question, open in part because the iMessage protocol isn't documented, over when Apple says iMessage is end-to-end secure. Are they talking about user to user or user to cloud? So if law enforcement went to Apple and asked for historical iMessages, could they provide them? We don't have a good answer right now. Okay, so the very last point I wanted to make on design considerations touches on user experience. And increasingly, I think many computer security researchers are recognizing this is kind of the whole enchilada, that no matter how well you design a system in theory, no matter how well you design it in practice, if it's not very usable, then you haven't really accomplished much. And so let me give some concrete examples of where user experience have gone a long way in security and privacy. So there's a feature in the Firefox web browser called Do Not Track that is intended to limit data collection and use by third-party websites, so websites you don't interact with. In Firefox 4, the Do Not Track button was under the Advanced Preferences menu. In Firefox 5 and later, it's under the Privacy Preferences menu. So seemingly kind of meaningless user interface change. It's like just a different tab. It actually looks like, very roughly, that moving the checkbox from advanced to privacy doubled the uptake of this feature from its initial release. So user interface matters a lot. Another concrete example, there is a feature in the Safari web browser that blocks certain third-party website cookies, information that might be used to track the browser around the web by default. There are somewhat similar features in the other major web browsers, but they're not enabled by default. Roughly 80 to 90% of Safari users have third-party cookie blocking enabled. Roughly 1 to 2% of non-Safari users have third-party cookie blocking enabled. And I think it's, I'm an Apple user, and I don't think that makes me smarter than everyone else when it comes to configuring my privacy settings. So I think the thesis that sometimes gets bandied about, it's a little ludicrous, but the notion that, like, hey, Apple users just care a lot more about their privacy. Oh, come on. Yeah. No, right, like 80 to 90% versus 1 to 2%, it's the user interface. The last example I want to give is this update to Firefox that just moved into alpha yesterday. It's a patch I wrote that implements a feature very similar to the Safari cookie blocking feature by default. So presumably will increase adoption rates of cookie blocking in Firefox users from the low single digits up to high double digits. And unsurprisingly, the response from companies that are negatively impacted by this change, that are in the business of collecting consumer information of this sort, very hostile. The initial response from one of the trade group VPs was, I think, called a nuclear first strike or something like that. Yeah. And that's all about user interface, right? Firefox has had a third-party cookie blocking option for roughly a decade, but because this one's going to be enabled by default, users don't have to go hunting for it. The game is totally changed. So that's the closing note I wanted to make sure to include, that even if you have this right in theory and practice, it really takes very, very careful design work to make sure users can actually take advantage of one of these systems.
Rainey, can I answer that question in a slightly different way?
Yes.
Okay, so you guys should really check out the WikiLeaks spy files, because they're really it's crazy stuff is in there, and essentially what they are is a series of promotional materials produced by these companies that make highly advanced surveillance equipment for governments, and so some of these, and there are like PowerPoint presentations in there that these companies have produced, which they presumably trot out to the NSA and the CIA and the FBI when they want to sell this stuff. And it's incredibly revealing. I mean, you can see that there are programs that exist that enable, law enforcement and intelligence agencies to bug your phone in a way that not only allows the government to see what you're doing and read your emails and intercept all your communications, but also turn the microphone of your phone on, right, when you're not using it, to eavesdrop on you just when you're talking to someone in the same room, to take control over the camera and take photographs and video surreptitiously, all sorts of really crazy stuff. So there's like there's the interception side where the government presumably goes to Google, sometimes with a warrant, sometimes with a subpoena, to get information from the service provider. And then there's also the government installing malware on your machine, right? That's a whole separate issue. So they can actually turn your own computer against you. And I just, I think one of the really key things to note about what all of these promotional materials say, if you look through them, is they all say, we provide lawful interception capabilities to governments, right? What does lawful interception mean in the United States in 2013? It's not pretty. So, until we change the laws to reflect the basic, principle of American justice, which is that unless the government has individualized suspicion to believe that we're involved in a crime, probable cause, and shows that evidence to a judge and gets a warrant, they should not be involved in our business, right? We don't actually have assurances right now that that's what's happening. So anytime you hear lawful interception, be wary.
I want to, really quick, would the user, anybody on the panel, would the user realize that their computer was bugged in this way? Would somebody talking on their cell phone be able to tell at a glance? Everyday users, maybe not Jonathan and Sita, but somebody who doesn't have the ability to kind of, does the everyday user see? Is there any way that they would know?
Well, it makes your phone hot. That's one thing. I mean, literally, like, you know, if you're not using your phone and you touch it and it's warm, that's a warning that something's going on, that somebody's using your phone while you're not using it. I think the same is also true with computers. If you find that, you know, there's a program running somewhere on your computer that's taking up all kinds of disk space and you can't figure out what it is, that might also be a warning sign that something tricky is going on. I don't know, Jonathan, if you have anything else to say about that. But.
I would say if that's the case, then whoever wrote the malware wasn't very good. Malware has gotten a lot more sophisticated in the past decade plus. If an entity really wanted to go out of its way to compromise an end user's device in a way that was fairly surreptitious and had access to what in the field's jargon are called zero-day exploits, so exploits that are not generally known, have not been patched yet, or if a user just happens to be running old software and there are old exploits that can be used, it certainly could be very possible to take over a device. And I'm really glad Cade raised this, because I want to make sure to caveat everything I said about security in theory and in practice and the design of security with at the point at which your computer or your phone or your tablet has been compromised. The technical term for the security properties you've gotten are hosed. You are out of luck. You are hosed.
I'm going to jump in here to piggyback on not just the conversations that have. Am I not talking into the microphone? Thanks. So I want to jump on to what Jonathan was saying about security in theory and security in practice, because that touches upon some of the work that I do. And I also want to simultaneously try and ground the conversation potentially in a different way than it's been talked about thus far. So I'm a senior researcher focusing on digital inclusion and online surveillance and privacy issues, as Rainey mentioned, at the New America Foundation's Open Technology Institute. And for the past year, I've been looking at, if we want to call them a user community, I wouldn't necessarily use those words, but at a specific portion of the population that doesn't have access to the internet or is thinking about using the internet or internet-enabled devices for the first time. And so within this world of new users of the internet, I think that issues of privacy and online surveillance are perhaps thought about in a slightly different way. So, you know, a lot of the conversation here and a lot of the conversation among surveillance and or privacy advocates, not surveillance advocates, but and you know what I mean, has been around thinking about rights and individual rights and, you know, the relationship, for example, between having private communications and being able to dissent as an individual and free speech rights and all of that. And I think what I'm seeing in the field as I go out and talk to people is that, first of all, it's not just about rights, it's really about power, because the way in which both technical features of surveillance are enabled by corporations and then the practices that are put into place by either government or corporations that do surveilling and data mining and targeting and tracking and so forth, that affects to existing social inequalities. And I think that's something that's really important to foreground in this conversation. And related to that, it means that these issues around surveillance and privacy are not just about individuals, they're about communities. And so again, the communities that I'm interested in are the communities that don't have access to the internet or are just coming online for the first time, sit at the intersection of a variety of inequalities. They live in communities with high incarceration rates. They have, you know, the public schools around them are closing. They have low literacy rates. There are a number of problems that they confront on a day-to-day basis. So when you're talking about, Jonathan, the security in practice concept, most of the security solutions or the privacy protecting solutions that are in place right now are a complete failure for the end users that I'm looking at, right? They simply just do not have both the time and the know-how to download Tor and use it, to use a plugin, to use. Oh, well, I'll leave somebody else to talk about Tor. I don't want to get into that just yet. So, you know, the types of tools that are out there for people to use to protect themselves are really out of reach. I've looked at a number of communities, both through classroom observation, you know, people that are taking classes, Intro to Computers and Internet for the first time. I've talked to people in public libraries and senior centers, in anti-poverty organizations. This is not what people are thinking of first and foremost. They come to the internet and the type of surveillance that's in place is invisible to them, perhaps even more invisible to the average internet consumer or the average internet user. And they're a long way away from being able to understand how these practices of surveillance and corporate tracking take place. You know, if you're learning how to use the computer for the first time, you spend a lot of time literally trying to figure out where the cursor is on the screen and how to drag it to the other side of the screen, right? So I've sat in classes where instructors are trying to get people registered to an email account, right? And there are all sorts of problems that are involved in there, right? Some people don't know how to type on the keyboard. There are spelling mistakes. They need to ask the instructor how to design a password. The password is then recorded on a piece of paper that the instructor has. You know, the instructor may, for example, tell people to run through the privacy policies and consistent with other research on how infrequently people pay attention to terms of service agreements or privacy policies. They just click through it. It doesn't mean anything to them. What I'm trying to say is that for this portion of the population, learning is really, really slow. That's not to say that people can't learn or won't learn. It's that the expectations that I think a lot of people have around learning how to be the, you know, perfect privacy protecting end user is simply out of reach. And it's something that we have to think about as we're pushing these conversations forward, thinking about who the most vulnerable populations are and also thinking about end users. The other thing that I want to say is that in the research that I'm doing, a lot of the communities that I've seen, for them, privacy is really a luxury. It's not, people don't think about their First or Fourth Amendment rights, right? They come into a public access center, you know, say for example, a library. They're under pressure to fill out their benefits forms. They will ask the library provider to help them register for an email account. They don't have one, right? Again, all of this divulging of personal information happens over and again. And then on top of that, they're divulging more information to the benefits providers, whether it's for family assistance or you know, for unemployment or otherwise, to you know, again, reveal bits and pieces of their lives in ways that the ordinary or average internet internet user isn't normally subjected to. And I think when the conditions of your internet use are, when your entry into the internet is under a condition of chronic surveillance, there's a problem, right? And we need to think about how we solve that problem collectively.
Jonathan wants to respond. I just want to remind everybody that if you want to participate in the Twitter discussion going on, the hashtag is NCMRPriv, P-R-I-V. You can also submit questions there. Jonathan, did you want to respond?
Yeah, I'm really glad CETA raised sensitivity to different levels of knowledge, access to knowledge among users. Something else I wanted to make sure to flag as a sensitivity in this space, I think very related, is the issues around international users and international governments. Again, where level of knowledge, access to knowledge,
Talking to the microphone.
Language in some cases may be different. So too, the rule of law may be very different in foreign countries, and the very legitimacy of a government may be very different. So whatever the merits of American law in this space, and I promised I was going to wear my tech hat today, so I'm not trying to opine on that. I think we can all agree that practices in some other countries are really pretty concerning. So China, Iran, and so on. What we learned after the fact about Tunisia. And this, in fact, has given some rise to some tensions within the federal government around user protections against surveillance. So, for example, Tor, that's an anonymizing tool that operates at the network level, so below applications, above the physical link between your devices and the network, was funded in part by the Department of Defense. And the State Department has given out, I believe it's tens of millions of dollars to projects to promote privacy and security tools for use overseas. Meanwhile, we hear from the Department of Justice that there's a need to revise federal law, in particular a law called CALEA, the Communications Assistance to Law Enforcement Act, that would require certain forms of backdoors for authorized surveillance.
What do you mean by backdoor? Spell it out.
Intentionally designed loopholes in the guarantees I talked about earlier. So if you have a system that's designed to provide confidentiality, integrity, and authenticity, you build in from the get-go some way of undermining those very properties.
So that
so that, for example, if government were to show up with a warrant, then the provider of the service would be in a position to provide government with whatever information it requested. So an example of this in practice might be Skype, which for a long time did have some or at least is generally understood to have had very good security and privacy properties. And following the acquisition by Microsoft, there is fairly widespread speculation that some backdoors were built into the product to facilitate compliance with law enforcement requests. The jargon that gets kicked around the Department of Justice for inability to surveil individuals because of their use of technologies that have privacy and security properties built in is going dark. And so you may see in Hill hearings or statements out of various federal law enforcement agencies, there's concern around going dark. And we should have legislation to remedy the going dark problem. CALEA 2.0, as some pitch it. Related to this, and the very last thing I wanted to note is this iMessage issue that the DEA flagged this week, the inability to intercept iMessages, yet another instance of this tension. So here we have some part of the Department of Defense, some part of the State Department saying they want to facilitate building these tools, and here we have a memo out of DEA saying they're concerned that this tool that Apple's put in the hands of countless people provides security and privacy properties that they would like to be able to work around if, for example, they had a warrant to intercept iMessages.
If you've got a piece of paper with a question on it, just go ahead and raise your piece of paper and somebody's going to come around and pick them up. Peter, he talked about what we found out in Tunisia after the fact. He talked about all of these problems in countries all over the world. You've worked on these things. Can you respond a little bit?
Yeah, sure. Take what happens here and make it much more egregious. And, you can imagine the situations in Syria and Iran. And luckily, we've had some opportunities to really look at the files. And in Tunisia, once the government offices were raided, the same as in Egypt after the uprising there, we saw the transcripts, we saw the calls, we saw the text messages that were being recorded through surveillance equipment, often sold by providers in the US, in Canada, in England, that are perhaps still being maintained in a lot of these authoritarian, abusive countries. And it's sold sometimes through third parties, sometimes through third-party countries, often illegally under US law and our sanctions regimes. But the software has capabilities to monitor everything. There is some backlash once actually in Libya, some of those tortured and who were arrested and tortured for their communications were able to see those records. They filed lawsuit against the equipment maker, which is Amisis and part of Bull in France. There are a couple other lawsuits like that. This is all coming to light after the fact, unfortunately. And so one thing we do at Access is work with the company, the telecoms, because in situations lacking rule of law, there's little civil society can do. We talk about multi-stakeholderism and involving civil society in these questions, but a lot of times the companies jump into these emerging markets that lack protections, lack rule of law, and make a huge buck, and then find out 5 years later the contract was gotten through bribery, and users have been arbitrarily arrested, tortured. I mean, one anecdote I just want to share is in this Eurovision contest. It's like the longest running TV show in the world, I guess. One country, one act from every country in Europe, musical act or whatnot, is put forward, and you have to vote for some other country's act. This guy in Azerbaijan really loved this Armenian song. I just thought it was great. Voted for it via his cell phone. He was arrested and brought in for interrogation by his police force, asking why he voted for Azerbaijan's sworn enemy, Armenia. That only shows the extent and the real-time monitoring that's possible, but also how brazen these security forces can be. So it's something to think about, as we look around the U.S. too.
I see two people responding, and then I had another question. Why don't you, both of you go?
I was just going to say, I think that just to kind of draw the connection between what I think is happening, or what I think the problems are here domestically and what's happening abroad is, and Jonathan has certainly alluded to it, is there's a terrible asymmetry in the type of power that corporations have and governments have versus the type of power that the end user has. And, in terms of, I don't know what the mobile phone penetration rates are in Iran or China or in other authoritarian regimes across the world, but as these areas increase their usage of mobile phones and other mobile or web-enabled devices, we can only expect that this type of surveillance is going to increase. And so I think it is really a moment to think about how, as Jonathan referred to earlier, how do we think about privacy by default and privacy by design so that we can avoid some of these problems from the get-go.
I just want to take issue with what I think is often the false dichotomy that's created between this country and so-called authoritarian regimes elsewhere. I think that someone who, if he were alive to talk about it, would really take issue with that dichotomy is Abdul Rahman al-Awlaki, a 16-year-old U.S. citizen from Denver who was blown up by a U.S. missile strike fired from a drone while he was eating lunch with his cousins in Yemen. The U.S. government, is still imprisoning 166 people at Gitmo indefinitely without charge. The U.S. operates secret prisons all over the world at so-called black sites where torture still occurs to this day. A Somali journalist is currently being imprisoned right now at the direct request of Barack Obama himself for reporting things about actually CIA black sites and secret prisons in Somalia. So the notion that the U.S. government is a democracy and other governments are authoritarian nightmares, I think is really something that needs to be contested because I don't believe it's true, actually. So again, the U.S. is involved in extensive, operations that violate all sorts of basic human rights all over the world, and the CIA and the NSA and the FBI are using these technologies to pursue those programs. So I just really want to caution the dichotomy that people draw between the U.S. on the one hand and China and Iran on the other. I don't think it's so simple.
I'm getting a lot of really great questions in. A lot of them have to do with what are we supposed to do about all of this? I think like half of the questions are, but what are we supposed to do about this? And I want you to know that we're going to have at least a half an hour, I believe it's an hour and a half long panel. If it's not, someone should tell me soon. With that in mind, I am planning on giving, okay, it is. I am planning on dedicating at least the last half hour of this talk to the what do we do about it question. And maybe now is the time to get started. I thought this was a really interesting, well, actually there's one more question before we dive into that. I think that this is a particular issue we're sort of delving into. Are there particular groups that suffer more as a result of surveillance than other groups? Anybody on the panel want to kind of speak to that or have some insights into it? Sita?
So, historically, there are certain kinds of communities that have been targeted more than others. In the work that I've done around data profiling, I've looked at historical cases of non-digital profiling, so thinking about redlining, thinking about racial profiling, thinking about medical research and bioprofiling that's happened across time in the United States. So thinking about the Tuskegee case, for example, when African American men were targeted as research subjects and used unethically to discover or basically exploit them for discovery of causes of and effects of syphilis. So there's a long history of surveillance and targeting that happens, and that unfairly in the United States falls upon the most marginalized communities, mostly African American, increasingly Latino, increasingly new immigrant populations. And again, for me, it's not just a question of government surveillance, though I think that is a really important area of concern. I think it also relates to corporate surveillance. So now we see these technologies being used to categorize different communities in different ways. So there's been research out of Harvard University by LaTanya Sweeney, who's looked at people that do searches for African American sounding names and the types of advertisements that they're getting. And in fact, that some of the advertisements that they're actually getting are related to, I think it's called Insta Checkmate. So it looks at your arrest records and it basically facilitates the process of pegging an African American sounding name to incarceration history, right? And so there's a way in which we're categorized by these new technologies that I think really adversely affects both how you're perceived online and what you see online. And I think the repercussions are dangerous, sometimes as dangerous as being targeted one-on-one by the government, right? Because it means that you're being welcomed into a world where you're systematically excluded or you're systematically tagged in a particular way.
Yeah, I would just add to that in as far as government surveillance is concerned, I mean, it's very clear who the targets are. The targets are people of color, poor people through the drug war, which is a massive driver of government surveillance. Targets are immigrant populations, which are profiled extensively and surveilled through programs like Secure Communities and multiple other programs. They are Muslims, especially right now in this country. Muslims are the new communists, basically. And dissenters, anybody who raises their voice against the government and says, I don't like what you're doing. I mean, documents just came out last week showing that DHS was involved in extensive surveillance of the Occupy movement. Basically, like two people standing on a street corner warranted like a Federal Protective Service report, and all sorts of emails back and forth between people who are supposedly involved in protecting us from terrorism. So yeah, I mean, hardly anything really, I think, has changed since the bad days of COINTELPRO. And again, that's yet another reason why when we want to talk about how government surveillance impacts people in the world, we need to actually look at home as well.
We have a bunch of interesting questions, and I want to ask some of them. One of them was about ECBO reform, which we talked about earlier. We referenced the Electronic Communications Privacy Act. This was the bill passed in 1986, which was supposed to protect privacy, but now has dangerous loopholes. They're allowing courts to make the argument that they can have access to your email after it's 6 months old, or maybe they could have access to your location data. They have made those arguments. We've fought back pretty effectively, and also to your data in the cloud. The question is, given the willingness of intermediaries, and those are companies like Google and Facebook and such, to voluntarily turn over data to the government, how meaningful is ECBO reform, and what can we do about it? Does anybody want to take that?
I mean,
I could, but I've talked a lot, so
as a non-lawyer, I can take a stab at it, which is to say, I think that part of what we've been talking about on this panel is that legal solutions are not really the only solutions that are in place or that are in our toolkit to do something about the problems we face with the ever-shifting sands of surveillance and privacy online, right? From where I sit, I see very little hope in reform for not just ECBA, but also other existing privacy legislation, partly because it's such a complicated issue and it's so entrenched and lobbying is really powerful. And exactly as the questioner kind of implied, that corporations can and will do what they want, given a set of circumstances. So they may, in fact, turn over data if that is in their best interest, if that doesn't interfere with their bottom line, for example. So, for me, and we can talk about this later because I do actually want to hear what Peter has to say, I think that we have to think broadly about how we engage in this issue and where we engage in this issue and what kind of long-term struggle we want to commit to make things better. Peter?
Yeah. I'm not gonna speak against the power of some, really interested congresspersons to force some change by the corporations. Representative Markey just sent letters to the major mobile telecommunications providers asking about their assistance to law enforcement, and he got back some very revealing responses from every major U.S. telecom, showing there were 1.3 million requests for user data in 2011. That was 2 years ago. Think about what it's like now. So these weren't voluntarily given, but this was a very effective action by a congressman, and it set a precedent. And now we've got transparency reports, and I really suggest that you look at these from Google, Microsoft, Twitter, Dropbox, others. So this
what is in those transparency reports? What do they show in those transparency reports?
So they differ a little bit, which is good. We're still kind of working out the formula. The basic data is number of requests, statistics, aggregate requests, for user data, different types of data from your basic subscriber information to your content, your location.
So I just want to jump in there. Yeah. So he's talking about reports that are produced by companies voluntarily, Google, Facebook, that say how many times the government has come to them and said, I want to see user data. Go on. Yeah,
their policy is for complying with those requests, for processing those requests, who it goes to, what team of lawyers, how it's translated. These are requests often from foreign governments, and how many they complied with, and how many they rejected, and on what basis. This is just the start, and Google has shown this information for the copyright side as well, DMCA removal requests, we want more transparency, which lets us see, if the government's not going to reveal it. The UK government reveals this. They have a whole office that issues a report every year issuing just this kind of transparency data. It would be great if the US government released their own data. We can match against what the corporations say, but it's one area where they've been responsive, and we're pushing telecoms to issue their own transparency reports voluntarily.
I'm going to go to Jonathan, and what I'm going to ask Jonathan to do is talk about because I don't want to run out of time, what should we be doing? So you can respond to what he said earlier, but what is the takeaway for people in this room? We all have heard what I hope is terrifying examples of government surveillance and privacy invasions by corporations and how those two work together. What do we do about this? And I am afraid that some of these brilliant questions that came in I won't be able to get to, but I want to be able to actually go down the line and hear from each of the panelists. All right, we get it. It's terrible. What do we do about it?
All right, so I'll start with the ECPA question and then transition into
You've got to talk into the microphone.
Okay. So first I wanted to, and I'm cheating a little bit here. I promised I was wearing my tech hat. I'm gonna wear the law hat for just a moment. ECPA reform would work a substantive change in the law, so that there would be a heightened judicial preclearance requirement. The law enforcement agency requesting user information would have to make a greater showing than they do under the current ECPA statute, and so clearly it does provide greater protection. So I wanted to be very clear about that. The second point I wanted to make on ECPA was just why reform might finally pass. One reason is companies want their users to feel comfortable in providing their data, and that's one of the reasons why they've put together these transparency reports. And so it can be a good thing. Tech companies are starting to get their act together on lobbying, are starting to be very active in Washington. They do sometimes fight for their users. But I do also want to make sure to flag that there is a downside to that. To the extent tech companies are willing to fight when it comes to making sure their users have information and control about information that gets shared with the government, they're a little less pro-user when it comes to giving information control about sharing data with the companies themselves. So in fact, in the EU right now, there are some proposals for toughening up consumer privacy legislation, and US tech companies have taken positions that would undermine the law as it stands. So these initial proposals would have strengthened the law. Proposals out of tech companies would actually wind up diminishing the legal protections from where they are now. So just to emphasize that organized tech company lobbying, good on some issues, not so good on others related to security and privacy. And then the other reason ECPA reform might finally pass is just the courts are kind of doing it anyways. So courts are starting to say this statute is so out of date that actually it's gotten trumped by the Constitution. And so if law enforcement agencies think they're going to lose in the courts anyways, it becomes a lot easier to agree to a deal on Capitol Hill. Okay, that's all I wanted to say about ECPA.
Okay, you have 1 minute to say what you think we should do about this.
Okay, 1 minute, go. I think the low-hanging fruit on the policy and politics side is pushing for transparency. So getting consumer control into law is really tough. You need to get a coalition in many cases of regulated entities to agree. Getting data brokers or consumer data aggregators or advertising companies or companies that are in the business of providing data processing services to the government, all of these to give really easy and comprehensive user information control, that's a pretty long-term project. It's a lot easier to say, okay, at minimum, could you just tell people what sorts of stuff you're collecting, how long you keep it for, what your internal processes look like, even with some level of generality. Let's start there. I think that's a reasonable place to start, and in particular, I would encourage taking a look at legislation that's pending in California right now that would require some transparency about consumer data collection practices.
What's the name of that bill?
The name actually escapes me.
The Right to Know Act in California. I believe Rainey Reitman just blogged about this on the EFF blog, if you wanted to check it out. Cade.
Okay, so I think that there are actually a whole lot of things we can do. One, you need to join the ACLU if you're not already a member. Also, join EFF. Give us lots of money. You should know that the FBI has, I don't know, like 40,000 employees or something, and we have like 2. So if we're going to fight back against the government, which is obviously extremely powerful, we need more money, frankly. So that's one. Second, when you do join the ACLU and EFF and we email you saying, please click this, click it, okay? Really, because it like actually makes a difference. So please click the button. And then third, for like much more involved things that you can do, you can get involved at the local level, because we've talked a lot about sort of meta big brother issues, but we haven't talked about little brother very much. And little brother is also extremely real. And local police are increasingly acting more and more like intelligence agencies, collecting their own surveillance information about all of us. One of the ways they do these things is through advanced surveillance technology. So like license plate readers, for example. How many people in this room have ever heard of license plate readers? Great, that's excellent. I hope it's in part because of the ACLU's work. We've been trying to drive this issue home. We actually have a bill in Massachusetts right now which would limit data retention of license plate information. So, but what I'm getting at is that you can actually go to your chief of police in your city or your town where you live and say, what kind of surveillance equipment do you have? What do you guys use? Do you have license plate readers? What's your data policy? When do you delete that information? Write letters to your local newspapers. Write op-eds to your local newspapers, divulging what you've learned from your local police department. Go to your city council meetings and tell them that you're worried about this stuff. Ostensibly, we live in a democracy, right? And the citizens should be able to control what the police do. So we should exert some of that power and try to take control over our police departments back from the federal government, which for the past 10 years has been showering these departments with literally billions of dollars to buy all sorts of surveillance equipment that is then essentially sucked up by the federal government ultimately. So get involved by joining the ACLU, giving money to groups like EFF and the ACLU. Take the actions, please click the button, and then get involved at the local level. And if you want to learn a little bit more about how you can do that, go to my website, privacysos.org/local police. There's a whole lot of information there about how you can get involved. And please contact me as well if you want to do that. Sure, privacysos.org/local police. And last but not least at all, agitate, organize, get involved. It doesn't matter if it's about union stuff, fighting the banks, anti-war activity, because what we saw with Occupy Wall Street and with any social movement is that when you provoke the surveillance beast, it rears its ugly head. Surveillance is by nature secret, right? And so we often don't know what's going on. But when things like Occupy Wall Street happen, all of a sudden you see giant surveillance towers everywhere on the corner in New York, right? So provoke the beast. It will elucidate a lot of information about what's going on behind the scenes. Agitate the system.
So I'm going to say yes to all of the things that have been shared already, but I do want to focus on a few things that I think are particularly pertinent to the worlds that I live in. So yes, agitation is really important, but it's also important to invest in some long-term education and community building. There are ways in which you can teach people about privacy and counter surveillance, I guess maybe we'll call it, and it's reasonable for them to engage in that kind of learning, right? So what I'm talking about is empowering organizations that are on the front lines of speaking for and serving poor communities, communities of color, immigrant communities, immigrant rights, and so forth. And what needs to happen is those organizations themselves really need to become privacy aware, right? There's currently a huge deficit in how many of our activist organizations and social movement groups use and share information readily and advise their communities and constituents to use and share information. And I think that's an important area that we can improve upon. I think 5 or 6 years ago, there was an incredible push in the philanthropy community, in the philanthropic community, to really support social media and social networking without questioning some of the privacy and surveillance problems that might arise in being part of a networked communication system. We need to start thinking about that now, and I think the community groups that are closest to the most affected individuals are a great place to start. Second to that, and this is just my personal thing that I like to get across, is for people that are using public access internet points, public computer centers and so forth, please, FTC, Federal Trade Commission, National Telecommunications Information Administration, Federal Communications Commission, state attorney general offices, please stop advising that these users buy virtual private networks subscriptions to better protect their activities. It's simply ineffective and unreasonable to expect that the person that is unemployed and really desperate to find a job or has been kicked out of housing will be able to do this, right? So we need to think about, specifically for poor communities, better solutions that are the least burdensome on them. And I think that, again, what Jonathan has alluded to in terms of privacy by default, including technologies in public computer centers that are already ready. They already come to you as a user, able to filter out some of the problems that we're seeing, some of the types of surveillance that we're seeing. That is one step towards having a more equitable situation.
And Peter, what do we do about this?
Yeah, seconding all of what has been said. I just want to highlight a couple things. We've had some success with the Freedom of Information Act. I think it's a muscle that we need to flex constantly. There's some great letter generators online. I think the Reporters Committee for Freedom of Press has a great guide on this data protection regulation that Jonathan alluded to in Europe. It's not only U.S. companies that are lobbying, but the U.S. government is very heavily lobbying. And so just at Access, we'll be releasing soon some preliminary emails and documents that we've gotten through FOIA requests, Freedom of Information Act requests, that reveal the extent of the U.S. lobbying because they realize the interconnectedness of privacy laws in Europe, 27 member states, which are copied by Latin American countries, countries all over the world copy these data protection laws, and they understand that that could change the conversation in the U.S., and the U.S. government is lobbying hard there. Online campaigns, as I've said, We the People, the new White House tool is pretty fun, and I think most of our groups, Access, EFF, we've done some great work in collaboration. CISPA campaigns are one thing to look for right now. As far as your telecoms, I would say one major step for security is getting them to update the operating systems more often, to push these updates rather than forcing you to buy a new phone. So that's one thing you can push for on the consumer side. Also, watching the deregulation process in the U.S. The common carriers are trying to say that they're no longer obliged to provide access to everyone, and that's something that is hurting rural communities right now. So keep a close eye on that, and there are some great civic groups that are working on those issues. And of course, talk to your legislators about privacy, and get more letters to the telecoms and the tech companies.
Thank you. So I wanted to end by giving everybody in this room a couple of specific examples of ways that we have fought back and won against government surveillance. We don't have time for very many of them. I'm going to give one. I'm going to ask the panel to give one more. Then I'm going to make 2 announcements, and then we're going to be done. And then we're going to end early. I wanted to say that recently EFF won a victory against national security letters, which are the worst part, arguably, of the Patriot Act. These are secret letters that are given to, for example, ISPs, and they say, hand over this data, and ISPs are not allowed to even say that they have received these letters. These happen entirely in the dark, without any form of transparency, and it's a way that the government is able to access incredibly sensitive information about internet users. And we took on a client who is a mystery client. Even working at EFF, I do not know who this client is. And we have been defending this person in court, and we recently had a victory, which means that national security letters, for the time being, until they appeal at least, are unconstitutional. And maybe, Kate, did you want to end with an example of something done on the ground, local, that's been a victory against government surveillance?
Sure, this is actually a really, really hyper-local example and gets at what I was talking about before about getting involved in your local community. I don't know how many of you are familiar with Brookline, Massachusetts, right outside of Boston, really affluent area. So again, I mean, I think that your point about privacy and poverty is really, really crucial. Poor people's privacy is violated much more routinely than it is against wealthy people. But in this wealthy community where people are very educated and have the time to show up to city council meetings and write letters to the editor and write op-eds to their local newspaper, we were successful in organizing an effort that I think is actually, I don't know of any other police department in the history of the United States that's rejected federal money for free surveillance toys. And we succeeded in doing that in Brookline. This was a license plate reader that the Brookline Police Department wanted to get with money from DHS. And we basically said, look, you can't do this because the federal government is going to want access to this license plate reader information, which means that the FBI could be getting it, all sorts of unsavory characters. And essentially the population in Brookline organized. It's actually only a month-long campaign, and we won. The board of selectmen voted to oppose the grant, and then the police chief ended up buying the technology with town money, but that meant that they weren't subject to federal data requirements. And so it was actually, I mean, it sounds stupid, but it's actually a pretty excellent victory, just because we got a police department to essentially, we denied them access to free toys. So
Nice.
you can do it.
Thank you. So, are any of you on panels throughout the rest of the conference? Any other talks? I'm going to be on a talk at, what time is it? 12:30, Trevor? The talk we're giving. 1 o'clock. All right. And where is that going to be? Plaza 2. So if you'd like to hear me talk about freedom of the press with Trevor over there, I'll be in Plaza 2 at 1 o'clock. And then at 2 p.m., I'll be talking about the Trans-Pacific Partnership, a terrifying international trade agreement in Governor's Square 9. Again, 2 p.m., Governor's Square 9 for a terrifying trade agreement. I wanted to thank all our panelists. Could everybody join me in giving them a round of applause?